This isn't going to be a workshop where you learn a whole lot new, because interestingly enough, in the last couple of years, the lawsuits relative to the use of seclusion and restraint have dipped significantly. And I think that's probably because, and as I'll share as we're going through with respect to the history of the case law as it relates to the use of restraint and seclusion in schools, what seems to have happened is the cases generally are dismissed because they don't allege or the evidence is not sufficient to keep those cases in courts, because the standard of what I might call bad behavior on the part of school folks is so high. I mean, it takes what's called either intentional discrimination or deliberate indifference in some circles in terms of what the claims are brought under, depending on the statute, and I'll get more into this, or something, that shocks the conscience, which is a very, very high level of bad behavior on the part of schools. So you'll see that as I'm going through some of the history of the cases, even up to the latest case latest reported case that I could find with respect to the use of restraint and seclusion. So it'll update you. I mean, that's the title, Where Are We Now? What's Going On? And of course, I'm very familiar, fortunately, with what you have in Indiana. I pulled up those guidelines that came out 2013, and they're very, as far as I'm concerned, they're very good from the perspective that they incorporate a lot of the recommendations that came from the U.S. Department of Ed that are all in my materials. My handout's very generic because I wasn't asked to really focus on Indiana stuff. I knew that you would know that already, hopefully. This is really just kind of what's going on generally in this area. And will there be changes on the horizon as it relates to federal activity? But based on what I looked at from Indiana, and of course I know that school districts have the discretion to take that and maybe modify it, it's very well done in terms of the common features that you see in laws across the country that have been put in place relative to the use of restraint and seclusion with students in schools generally, not just necessarily restricted to the analysis of how it applies to students with disabilities. Interestingly enough, those states are different on that. In Florida, their laws only apply to the use of restraint and seclusion with children with disabilities. And I feel like it ought to apply generally to all children, not just children with disabilities. But Florida's legislature, I don't know what they were doing, but that's what they decided to do. But the guidelines here are for the use of restraint and seclusion for all students. So that's a little bit different maybe from what another state might say. All right, as I mentioned, 2009 was when Congress actually took note. Congressman Miller, George Miller in the House, must have had some anecdotal stories presented or must have known that this was a concern in schools generally. He was out of California. He's no longer in Congress, but in 2009 he kind of took this on as a big issue. And actually they commissioned, the Congress at his behest, commissioned the Governmental Accountability Office, GAO, to do a nationally based research project on the use of seclusion and restraint in schools. And I don't know how many of you have actually seen the report that came from the GAO, a very lengthy report talking about specific instances of the misuse of restraint and seclusion across the country, where students were significantly injured, or in one case a student died in a seclusion room. And I'm actually going to talk about that case. But it was full of anecdotal stories, and it got everyone interested at the federal level. Other members of Congress then became very interested. So Congressman Miller introduced legislation in the House that passed the House, but as you know, and of course I have to revisit, how bills pass and all of that kind of thing, but as you know, the Senate has to pass something too, and then they jointly work to try to iron out the differences before they can propose a bill. And when it initially started in 2009 with the bill introduced by Congressman Miller, It passed the House, but when it got to the Senate was on to other things. Nobody really picked up the torch in the Senate to really take a look at it. So it, after the passage of time, bills expire that are actually proposed. So the next time it came about, it was a Senate proposal. And then it just kind of wavered. And the most recent activity was in February 2014. Senator Tom Harkin of Iowa, and I actually refer to him as Senator IDEA. He's always kind of been on the forefront. He's been around throughout my entire career and always in the forefront on IDEA issues. And so I've always called him Senator IDEA. He's retired this year. And so we are kind of without him, and I don't know who's going to carry the torch. The name of the congressional law, the Senate bill that he actually introduced in February 2014, is Keeping All Students Safe Act. So if you're interested in the provisions, I usually don't feel it useful to review provisions of something that I know is not going to be the law. It had some interesting things in it, some things that worried me as a school attorney, but it went nowhere. So it's doubtful, although I have always open to being proven wrong. But it is doubtful to me that someone's going to pick that up now. And it's probably because we may not need it. States have stepped to the plate since 2009. When that report came out of GAO, and it was very serious, I think the handwriting was on the wall and states started to feel like maybe we better do something. And I think the U.S. Department of Ed was interested in trying to get states to do something rather than Congress legislating in this area, for fear that states would then be bound by too many details coming from the federal law. Let states do it. And in fact, the U.S. Department of Ed took that position. Give us a while and let us get the information out and let state legislatures step to the plate and come up with things, or state departments of education. And so throughout the country, we are seeing action being taken in terms of states taking what the federal government has issued, taking examples from other states, whether it's through actual legislation or whether it's through guidelines that come down from the State Department of Ed, or whether it's a little bit of both in terms of rules, guidelines, policies, procedures, that kind of thing. So most of the states have stepped up to the plate and have something. And that's the USDOE's reason for saying to Congress, maybe right now it's not necessary. However, there was a concern coming from Senator Harkin that while you have all of these states doing things, where is the standing, as we lawyers call it, for a cause of action? If indeed a state policy or a school board policy isn't followed, how do you remedy that, and is there an avenue for doing so? So Senator Harkin, in the last attempt to introduce something, was interested in the language of that proposal actually set forth a private cause of action for violating any of the provisions in that particular statute, rather than forcing parents to figure out what theory they might use to obtain some potential money damages. And that's generally, in the court cases historically, that's the remedy being sought. If my child was either emotionally or physically injured, therefore we want big bucks. Sometimes legitimate requests, others maybe not so much. But we've had, regardless of whether there's federal legislation, regardless of whether the state of Indiana decided to do anything in this area, there's still potential for litigation, because there are constitutional rights at issue here: bodily integrity, liberty, privacy, due process, all those kinds of things. And the cases predate any of this initial discussion in 2009 with respect to legislation. We've had these cases going on for a long, long time, but they spiked 2010, 11, 12, some in 13, but I saw a significant decline in these cases seeking money damages remedies for the use of, or the alleged inappropriate use of, seclusion or restraint in schools. So it's been kind of an interesting area to the degree that I follow these cases. I've always followed these cases. From the 80s, I followed these cases because they were of concern to me, seeking money damages. And I was always interested in the money damages cases because, like I said this morning, I did make a personal choice that I did not want to be a personal injury lawyer. Never wanted to see myself on TV. You know, have you been injured in that IEP meeting? One call, that's all, you know, that kind of thing. Boy, I think it was yesterday. It was yesterday. I had my TV on, and I don't know if any of you had this in your room. You may have, and you didn't know it because I didn't know it. But I walked into my bathroom, and there was a TV remote control there. I was like, well, that's odd. So I'm like, I wonder why it's here in the bathroom. They had a little TV listing. So I pressed the power button, and the TV came on in my mirror. It was really cool. So I was, you know, I had it on. I was doing some things as I was getting ready, and I didn't present till yesterday until the afternoon, so I had the morning. And I have never seen so many ads for lawyers. And they all had their little, you know, and they're personal injury lawyers. And this is a personal injury area in the area of special ed. But I was really struck by how many. I mean, usually you do see those during the daytime, no matter where you are. But man, it was like one after the other after the other. So there's a lot of Indiana lawyers trying to get this kind of business, this personal injury business. And they don't have to necessarily be a special education legal expert. And most of the time when I see these kinds of money damages, they're not special education attorneys typically. They are personal injury lawyers. And that's because the remedy being sought is a personal injury remedy. It is not a remedy necessarily, although we've seen a little trending that I'm going to talk about, not necessarily seeking services for the child. It's really more seeking money damages. At the bottom of, beginning on page 1 and over to page 2, I did want to just point out that although your Indiana guidelines are much more extensive, the starting point for states was this document, this resource document that I referenced at the bottom of page 1 and over to page 2 that came from the U.S. Department of Ed. And there are definitions there, but your Indiana guidelines have that. As you may or may not know, there was a commission formed pursuant to Indiana law, a commission of 9 members, important stakeholders from all groups, that was by law required to get together to formulate these guidelines that came out. The deadline was July 1st, 2014, but the model plan came out on August the 1st, 2013. And so if you've never seen it, which I'm sure you have, you can Google it. It clearly comes up. It's very easily obtainable in terms of Indiana's commission guidelines on restraint and seclusion in schools. And by July 1st, 2014, every public school district here in Indiana was to adopt something, whether it was those model guidelines or some revision thereof of those guidelines. So those are all in place, and prior to that, and I know I could tell that the commission actually used the USDOE's resource document because a lot of the language is very similar, and that was the intent. That was why the USDOE put this out. Most importantly, beginning on page 3 of the materials, were 15 principles set out in that document. And that's what the resource document is primarily known for. And I used to take those 15 principles and train principals, P-A-L-S, but principles of restraint and seclusion for principals at school. And I used to use these 15 principles on page 3 and over to page 4 because they are a good outline of everything we need to know about restraint and seclusion in school. These are very common. These are sort of common themes that I see throughout the country when I'm looking at guidelines, rules, regulations, or actual laws in states. They are all some form or fashion adopted a number of these principles, and all of these principles are in your Indiana guidelines, but there are actually additional principles in the Indiana guidelines. There's like 18 principles in your guidelines versus the 15 that were set out in the U.S. Department of Education's resource document. And there are a few things that are a little bit different, such as the suggestion here that it is not authorized to use prone, face down, or face up on the back restraint. All of those kinds of things are a little unique, perhaps, to Indiana. There are some details that are a little bit different. But I'm not really here to train you on those guidelines. Mine's really more from a national perspective. What's going on? Where are we now? Where might we be going as it relates to restraint and seclusion? All right, so that leads us then to what some courts and agencies say in this area. And again, this litigation has been going on since the 70s. Regardless of whether Congress does anything, regardless of whether Indiana law required any commission of any sort to get together and create a model plan, which has all been done, but prior to that, there was litigation. And litigation that stuck. Because again, the inappropriate use of restraint or seclusion could implicate a number of rights, civil rights, that therefore could be the basis for filing a lawsuit. So on page 5 of your materials, and what I actually did was just come up by way of example with some things that you can look at to show what the kinds of themes were in these cases, and maybe perhaps what courts were ruling on, and these, or how they were ruling. Some of the claims they were ruling on, how they were ruling on them. In terms of bodily injury, many, if not most, of the cases are brought and have been brought, as I set out on page 5 of your materials, under the U.S. Constitution. They're constitutionally based claims. And that's what I like about this area of law. It makes me stay on my feet as it relates to being current with constitutional issues. I mean, all kinds of residency issues, parental rights issues, all kinds of different things come up in our practice. That's why I told my law partner it never gets boring. She's always fascinated by how much research we have to do, even though we are specialists. We still have to venture into constitutional claims and things like that. And the interesting thing, the Constitution doesn't really give people a right to sue. It's just the Constitution. And we know we can't have our rights violated, but what do we do if they are violated? So what effectively was put in place in the 1800s was called Section 1983 of the Civil Rights Act of 1873, basically. And it was put into place to put teeth into the Constitution. When there were folks or groups of folks whose civil rights were being violated under the Constitution, they needed an avenue for a remedy. So what Section 1983 does, and this is a very, very generic explanation. Some courts don't even understand Section 1983, so I don't know how I can basically say that I do, but what I understand that Section 1983 does is to provide a statutory avenue for obtaining remedies for violations of constitutional rights or violations of other rights created by another statute that does not carry any remedy. The Constitution doesn't. It declares all of these rights that we have as individuals that live in this country, but it doesn't give us an avenue for basically challenging someone's interference with those rights, for lack of a better word. So, Section 1983, you will see in a lot of law conferences, a lot of handouts, you'll see references to Section 1983 when there is some discussion of money damages. And money damages comes up in this area, the use of restraint and seclusion, but we also see it very often in bullying cases now, disability harassment cases. Typically 504 and ADA serve as the avenue, but Section 1983 makes its way into those cases. Or other kind of just what I might call run-of-the-mill personal injury cases in special education, where it appears that a paraprofessional or a special ed teacher was having a bad day and acted very inappropriately. And those are the kinds of cases like school bus accidents, or the last one I remember, a student with physical disabilities and medical complications fell off the back of a bus during a bus evacuation drill. But it was a federal lawsuit that was being brought under Section 1983 for failure to protect that child's rights, et cetera, et cetera. So we see a lot of those. So that's what we see in restraint and seclusion. These theories, my rights were violated under the Constitution, and I'm using Section 1983 of a federal statute to get remedies for those violations. So we have all kinds of different constitutional claims as it relates to restraint and seclusion cases, either claims brought under the 14th Amendment's Due Process Clause or the 5th Amendment's Liberty Interest Clause. Sometimes we see these cases brought for money damages under the 4th Amendment, particularly as it relates to seclusion and search and seizure being the most important piece of 4th Amendment, an illegal seizure of a student and putting them in a seclusion room, so it might implicate the 4th Amendment. Then we also from time to time see cases brought under the 8th Amendment, although I have not seen that in a long, long time. And the 8th Amendment is the one that prevents cruel and unusual punishment. So there have been over decades of these cases being brought. This is not something new. These have been around for a long, long time. Over decades, we've seen all kinds of different theories brought under the Constitution, but the avenue being used is Section 1983. Sometimes also, we might see these brought as just plain, pure personal injury cases under state law. But many times, state law carries a significant amount of what's called immunity for state employees and corporation, school district employees against accidental damage. So there's a high level of immunity in state courts. That's why many litigants prefer to go to federal court. And that is what we've seen, most of these going to federal court. So I have a few of these cases, and certainly this isn't all of them. If I tried to put all of them in, we would have been here for several hours, which I can assure you on a Friday afternoon would not have been your pleasure. There are so many cases that I've really kind of just chosen basically some of my favorites. And you'll see, they go back to the 70s, some of them, and the 80s. You know, and the point I'm trying to make is that even though restraint and seclusion did not become an issue for Congress until 2009 and states started to take it very seriously, it's been the subject of litigation for quite some time. And whether or not the federal government does anything, whether or not Indiana decided to do anything, there's still a potential cause of action for the inappropriate use of restraint or seclusion in school. I've always included these cases in I do a year in review many, many times. I keep up with all the cases all year long. So almost daily I try to read at least 2 or 3 cases so that I can keep up. And I've always had in that section of my year in review money damages cases. And seclusion and restraint would pop up ever so often. But then I saw a trend where 2010, 11, 12, 13, there was a whole group of them. So I even took them out and called them restraint and seclusion money damages cases rather than just plain old personal injury money damages cases. So they've always been around. But we saw a significant spike when Congress got interested, and now it's going downhill in terms of the frequency of these kinds of money damages claims. But you'll see, again, as I said, a number of different themes with constitutional cases being addressed first. And one thing that comes up a lot in these cases, as demonstrated on page 6, for instance, in the Jefferson versus, I'm not sure how to pronounce that, but I've heard it's Yalita School District out of the 5th Circuit. There is a theme in Section 1983 cases when school officials or other school personnel are sued for money damages remedies under Section 1983. Just like in state court, there's something in federal court called qualified immunity. And what qualified immunity really means is someone who is sued personally under Section 1983, and these are usually personal lawsuits brought against the individual bad actors, and then also against the school district generally being responsible for its employees. And those are the allegations. But when individuals are at issue, there is something called qualified immunity under federal law. And the standard is, in terms of whether it applies and therefore would mandate dismissal of that individual from the lawsuit, the standard of the question is whether this person who has been sued in their role as an assistant principal, school teacher, whomever, in that role, would a person in that role have known that they were clearly violating someone's rights? It's clearly established law. Or was this just someone who acted negligently, had no idea what they were doing was a violation of someone's rights? So in this Fifth Circuit Court of Appeals decision, which got a lot of attention in the 80s, 1987, we had a teacher and a principal who acted together to tie a second grade student with a disability to a chair for the entire school day, and then for a substantial portion of the second day, and they called it a, quote, educational exercise. But the court saw no evidence that supported any kind of justification for this, quote, educational exercise. Now, both the principal and the teacher basically claimed they should be dismissed from the lawsuit based on qualified immunity. And this court said, if these facts are true, if this is actually proved in court, it is very clear that the student's 5th and 14th rights, constitutional rights are implicated. And it is also very clear that a teacher and a principal would have known, clearly known, that tying a child to a chair for a day is violative of a child's rights. So we're not dismissing them from this case. Now, generally what happens in these cases is we never hear about it again. Because at this point in time, what this court is saying is we're not dismissing it, it's going to trial. And what happens at that point is insurance companies step to the plate and they settle these cases. So I can't tell you about a case where there was an inappropriate restraint or seclusion and the family got big bucks. Because usually these settle and we don't know what happened. So these are generally cases that come up in what we call motion to dismiss stage, where someone's trying to have the lawsuit dismissed either based on qualified immunity or because there's not sufficient evidence to support the claims. The Metzger case, I remember reading this in 1988, and secretly I don't share this with very many people, but I'm a professional wrestling fan. I started watching when I was in high school, and it's sort of like reality TV is today. It's that train wreck you just can't turn away from. I guess I got into that really early in life. I was crying one time when Mr. Wrestling #1 in Atlanta was a big center for professional wrestling, and that's where I grew up. And I was crying in front of the TV, and I remember my mom came downstairs. She said, "What is upsetting you?" And I said, "Mr. Wrestling won. They just ripped his mask off, and we all know who he is." And it was just, she goes, "Julie, you know that's not real." And I did not know it wasn't real. It was like she told me about Santa Claus or something. But I still watched it. And when I read this Metzger case, it appeared that the PE coach, the coach, was using the sleeper hold on the child, let's just say. And Sting was really good at the sleeper hold, so I tend to know what that is, where he wrapped his arm around the neck of the student and actually put the child to sleep because he was holding him so tight. And when he released the child dropped to the floor, the hard gym floor, and busted his jaw, teeth, there was blood everywhere, that kind of thing. And so it was considered a restraint of some sort under constitutional themes. The 14th Amendment, excessive force was claimed, and that kind of thing. The coach basically came in and said, but my decision to discipline, there's a lot of discretion there, I should be dismissed. And the court said, no, there's going to be a trial over whether you used excessive force under the circumstances. So these are the kind of complaints we were seeing early on, at least in my practice. The Heidemann case was very famous nationally at the time for the use of what was called blanket wrapping therapy. So the child is wrapped very tightly in a blanket, according to the case when you read it, and evidently spent a lot of time wrapped in this blanket that was considered by the school district, and more particularly a licensed occupational therapist who had suggested this as a calming technique, sensory kind of thing. Well, mom didn't know too much about it, but just happened into the school for a visit and observed the child on the floor, on a mat, in this blanket for a long period of time. She went to a lawyer and said this was inappropriate restraint of my child. I wasn't there, so I don't know what this looked like, but there was a huge lawsuit on this. And it was all about whether or not this was unreasonable, whether there were constitutional claims at issue. And the court, and some of the courts will also look to the qualified immunity issue, but they'll also look to whether or not folks were reasonable under the circumstances, which is, kind of depends on who's deciding, right? But we see a lot of these cases where it's up to the court to look to see, is there enough here for this to go to a jury? But based on the fact that a therapist, licensed therapist, had suggested this as a proper method for dealing with the behavior problems that this child had, based strictly on that, the court did dismiss the case based on qualified immunity. That none of the professionals at the school that were using the blanket wrapping therapy had clear knowledge that they were violating someone's rights, and it was because a licensed therapist suggested it as an appropriate therapeutic technique. I will tell you also, in 1996, when this litigation was going on, those who were using blanket wrapping therapy across the country stopped. Because sometimes all it takes is one lawsuit for us to think about, how that might impact, So, and districts were using some form of this sort of. When you read the court decision and the allegations, it kind of sounds like a straitjacket a little bit. But evidently there were therapeutic components, according to the therapist and other therapists across the country. It was something that was used widely until this case came down. I don't hear of it anymore. Now, of course, I'm not going to hear of it. It could still be going on. They're just not telling me. But I have not heard of this kind of therapy in a long, long time. The Brown case in 2000 was one challenging the use of something called the basket hold. Interestingly enough, some of these cases, the courts recognize in some of them that the IEP for the child or the behavior management plan actually contemplates the use of a restraint or seclusion technique. Now, I will tell you, as a school attorney, I prefer that those kinds of things aren't included necessarily, particularly in behavior intervention plans, because I don't think this is behavior intervention. I really don't. I think it is, if we're talking restraint, seclusion, not timeout, that's different, completely different. Your Indiana guidelines actually make that very clear, totally different. But if we're talking about the use of this strategy to prevent that student from hurting self or others, because there's an imminent danger, and that's the constant that we see in all of these policies and procedures across the country. It's that imminent danger, last resort philosophy. I don't think that's behavior management in the sense of what IDEA refers to as conducting functional behavioral assessments and developing behavior intervention plans. But I have seen courts look, and if that's in the IEP or if that's in the behavior intervention plan, a court might say that the fact that it's there put the parent on notice, and therefore they didn't object to it, therefore it's not unreasonable for the staff to use it. And that was the case in the Brown case and in some of the others that I list here in the materials. There are other themes, constitutional or otherwise, used in these cases. Section 1983, again, the most prevalent, but like in case H, we had claims under Section 504 in the Americans with Disabilities Act. Of course, those are anti-discrimination statutes. So the allegation is there was some form of discrimination relative to the use of restraint or seclusion. There are a couple of cases that are disturbing to me as a school attorney. Bottom of page 7, case J is one example. where tape is put on the body of the child with a disability. Based on that, I've generally advised school administrators, just go into your closets and remove all tape, whether it's masking tape or duct tape. Duct tape is more dangerous because I've seen it in cases more than I would like. I mean, actually surprising situations. The WET case out of North Carolina on the bottom of page 7. When you read the case, you can feel, I guess, a lot of frustration on the part of this teacher, but also maybe she's frustrated, but she's taking it out on the student, which is unfortunate. A multiply disabled student who was talking a lot in class. And when he was at one point talking to a classmate, the teacher taped his mouth shut. Now, who thinks this is a good idea? You know, someone's having a bad day, but I always say, take your medication and don't take it out on kids. You know, these kinds of cases create a bad name for schools. This is why it got to Congress in the first place, some of these anecdotal stories, that this was rampant in the schools. Well, more so, frankly, than I thought, but we have these anecdotal cases, and Congress hears of these. So the teacher tapes his mouth shut. Now, he has asthma, too, and some breathing problems. So this is just for a number of reasons not a good idea. And when he's trying, she asked him a question, so he's trying to talk from the tape. You know, with the tape over his mouth, he's trying to answer her, and she goes and rips it off his face. And the court said, you know, under these circumstances, we don't think a reasonable educator would have reason to think that that was okay. That's clearly unreasonable, therefore she's not going to get off on the qualified immunity defense. So that's what we see a lot of these cases now. Do we know if that family got any kind of money damages for that? We have no idea. But most of the time, the insurance companies come in and say, okay, now where are we? Okay, so we got to pay the lawyer for the district or the lawyer for the individual. We're going to have to pay them, even if this individual didn't do anything wrong. We're going to trial. So we're going to have to pay at least $100,000 in attorney's fees to get there. Why don't we settle and pay half that to the, you know, that's what happens in these cases. So it's very personal injury oriented. That's what happens in car accident cases, all of those kinds of things. So it's very similar. The OH case is interesting to me only because I'm very familiar with this school district. It's one that I consult with. This happened before I actually started working with them a couple of years ago. But this case put a lot of people's work on hold because they had to spend so much attention on this case. Now, the school board was actually sued also for hiring this particular teacher. This was a teacher who rolled an autistic student who she placed in an ill-fitting wheelchair of another student. Because he was acting out, she rolled him into a nearby storage closet as his timeout or seclusion. She called it timeout. The litigants obviously called it seclusion. Strapped the student, confined the student, therefore it is a form of restraint. And then moving the child into a dark bathroom storage closet was a problem in and of itself. And the court refused to dismiss that case. Said those facts sound unreasonable, sounds bad enough to keep this particular case in court. I did talk to the school people. Did you all settle this? Yes, confidential settlement, so they can't tell me exactly what. But they did settle the case. And again, that's what usually happens. So I don't have any of these great stories I can display. Well, this family recovered $5 million. That may be the case, but we may never know about it because many times the settlements are confidential and they certainly don't show up in court cases. The King case. The King case, remember that GAO report that I talked about that Congress commissioned back in 2009? The King case was an anecdotal story that got everybody's attention. And this was the use of a locked seclusion room in a program in Georgia that was when I practiced in Georgia a lot, when I got my start there, the program for seriously emotionally disturbed children was called the psychoeducation program. It was a network of therapeutic day schools. Now they changed the name because people really did not like the reference to psychoed. I mean, at the initial reference was the variety of services, psychoeducational, but a lot of parents objected to their children being placed there. I remember one parent adamantly saying, "My child's not psycho." So it was perceived by a lot of parents as institutional. So they changed the name to something like GNETS, Georgia Network of something. I can't even remember what GNETS stands for, but it's much more palatable. But those are special therapeutic day schools for the most severely emotionally and behaviorally disordered children in Georgia. And this was one of the GNETS schools where this happened. Evidently, they allowed this emotionally disturbed child to wear a rope around his pants as a belt because his pants were falling down. So they found a little makeshift belt. It was a rope that he tied around his waist. Well, he was acting out, and he actually escorted himself to the timeout room, the seclusion room that they had there. And these were the only facilities in Georgia that had these seclusion rooms that were locked, and apparently approved by those who need to approve them or whatever in Georgia. This young man was smart enough to know when he was in that room, locked in that room, how often people would look in on him. They had a procedure whereby they had to check in every 3 minutes and document everything that was going on. Well, he knew when they weren't going to be looking, and he took that rope and he hung himself in that seclusion room. And this was the anecdote that got a lot of attention in terms of a child dying in a seclusion room. In Georgia, do you think they use seclusion anymore? No, not after this case. But the interesting thing about this case, it did go to trial. It went full through trial. It even went to the U.S. Supreme Court for review. And what the court said was, the standard of conduct on the part of school personnel, there has to be some intent there. While this was negligent, clearly, to let an emotionally disturbed child wear a rope around his waist in a locked seclusion room, not good judgment, but there was not the sufficient intent to harm that child. Was it negligence on the part of the school personnel who knew he was there, who escorted him into that room, and the director of that program? Should that have been done differently? In hindsight, sure. But the level of bad behavior it takes to get money damages in federal court in any context, including seclusion and restraint cases, is so high. And that's why I actually think that the litigation has dropped off. I mean, even in the most severe case, there's no money damages awarded at the end of the day because of the federal standards. What you have to show to maintain a constitutional claim under Section 1983. So even though the facts sound bad, even though everyone admits that the facts are bad, there was no one who intentionally thought that that child would do such a thing in the seclusion room. But in Georgia, they outlawed seclusion rooms. They shut those down. They do not use them anymore. A lot of states have done that as well. But in Georgia specifically, even though there was no money damages at the end of the day, they decided we're not going to allow for the use of locked or unlocked seclusion rooms in schools. So now they're being used as storage closets and things like that in the state of Georgia. D.D. versus Chilton County Board of Ed, a Alabama case. So again, what I said generally was, many times in a constitutional sense, it requires intentional behavior, not just negligent, not just bad judgment. Here we have a teacher who Velcroed a 4-year-old student with autism into a Riften chair. Now, Riften chairs have gotten a bad rap in terms of their inappropriate use. School professionals using them to control behavioral problems rather than using them to position students, which is what they are made to do. So when some sort of equipment is used in an inappropriate way to restrain a child, here potentially we might have one of these kinds of lawsuits. And I remember when this case started in Alabama, not my client, but boy, did news spread across the state in terms of this one case, and everybody better be making sure they're not doing this. But the interesting thing was the special education teacher actually said that she asked the child, would he rather be in the classroom? He was having major behavior problems. Mom was called. They were waiting for Mom to come pick him up. She said, do you want to be in the timeout corner in the class, or do you want to sit out in the hallway in this chair? And he said, I want to be in the chair. The court said, I'm sorry. You're relying on a 4-year-old with autism to tell you what they want? But at the end of the day, the court said this was bad judgment on the part of this teacher. However, the child was only there for 10 minutes. Mom shows up. She's ballistic when she sees what's going on. But he was only there for 10 minutes, and there was no evidence that the child was harmed in any way. Now, you do have to show harm in order to get money damages. The mere fact that something bad happened, if at the end of the day there's no damage, there's no therapy needed for the child, there's no physical injury at all, that might decide the case. And that was the decision in this particular case. But boy, did it get a lot of attention in Alabama, I can tell you that. Is anyone using Rifton chairs? My clients have stopped buying them. Even for kids who need them to be positioned appropriately, they're afraid if they have them, they'll be used improperly. I'm like, well, that's a little much. But when we're talking about Velcro, children Velcroed into a seat, I've seen cases where bungee cords were used, tape, all those things. Oh, no. We shouldn't be doing that. Those are the cases that get Congress interested in this. Never have I seen a law that says we have to get parental consent to do so. It's all about, have we defined what imminent danger means? I think that's really important. And I think one thing that I liked about the guidelines that I saw in the Indiana plan, the model plan, this is what is appropriate, this is what isn't. And I think that's really important because I see a lot of this is appropriate, this is what constitutes imminent danger, but I don't see the other side of that, the what isn't. And I liked those examples, and I thought, oh, I'm going to take that actually and recommend to some of my districts that they do a little bit more with that. But the bottom line is there is no requirement for parental consent. If that child is an imminent danger to self or others under our standards, and we've trained people to do what they need to do, and they follow all the procedures, there's not going to be a cause of action. And generally, I have advised my clients not to seek consent. But it's advisable to put parents on notice. And even if they tell you absolutely not, you then explain kindly that, boy, please understand it's our last resort, but if your child is a danger to others, imminent, and you go through that explanation. Every time a parent has tried, there's one where they use bus restraint. The parent actually sued the 11th Circuit Court of Appeals, and I'll point the case out in a second. But the parent sued because he did not give consent to them using a harness on the bus, a restraint. And the court said all they needed to do was put you on notice. Consent is not required because it's within the discretion of professionals if they view the child's behaviors as being imminently dangerous to others. And on the bus, his running around was dangerous to everybody on the bus, what he was doing. And so there is nothing, unless your state law, which I didn't read it in the plan, says that consent is required, legally it's not. So you have to delicately explain to the parent that we're going to do everything we can not to, but understand if it reaches this level, then we will. It makes me very uncomfortable. I've got clients that send me videos to watch, and it's really hard, the restraint thing, because the video really doesn't pick up everything that's going on. And so we see a lot of those kinds of scenarios. But even in the worst scenarios, you still don't see money damages. Did it drag somebody through that teacher? She's never going to ask a 4-year-old again whether or not they want to be strapped in a Rifton chair, I can tell you that. but there weren't any money damages at the end of the day. So the best you can do is just explain that to the parent, that you don't necessarily need consent. And that's why I tell my clients, let's don't burden ourselves and go with consent. We just explain to parents that, it was interesting, the kind of initial reaction I got from clients on this issue. Even some superintendents would tell me that we're not going to spend the money on that CPI training anymore, or whatever it might be, because we're just not going to restrain at all. We're not going to take the risk. I said, so now you're going to take the risk that someone's injured, because we all stand back and go, oh, sure wish we could restrain. So, and I told him that, and he's like, oh, I never thought of that. So they're doing their good CPI training with the intent that hopefully we never use it, but if we have to, we've trained the people who foreseeably could be the ones that would be asked to restrain a child. And they have actually made the point that they were going to back away from, and it's really focused more on de-escalation and how to respond, all of that. And they sort of changed their tune a little bit in their training. They fine-tuned it a little bit as this whole issue became something that Congress was interested in. Oh, absolutely. So, I don't want to bore you with all of these cases. I've kind of hit the highlights just to demonstrate that there are constantly these cases, and they've been around for a long, long time. One of my very favorites, it's in the Fourth Amendment cases section on page 10. It's out of Hawaii. It's case B, Doe versus State of Hawaii, where an assistant principal thought it would be a good idea to tape a child's head to a tree out front of the school. And I love this because the court said, in terms of qualified immunity and whether an assistant principal would have reason to know that was violative of someone's rights, the court said even a fifth grader knew that was the wrong thing to do. So I call this one, Are You Smarter Than a Fifth Grader, that case. But again, tape, there are a couple of, as I mentioned to you, some cases involving putting tape on a child's body, which I just, clearly think is a real bad idea. I did want to point out, though, beginning on page 12 and over to page 13, there are actually FAPE cases, too, where the inappropriate use of restraint, the allegation is it's a denial of faith. The child is not able to meaningfully benefit from their education, therefore FAPE has been denied to the child. So we've seen a number of these FAPE cases, too. That's what I'm seeing more when due process hearings are requested. They know they can't necessarily go after money damages, certainly not in due process anyway, but probably not going to go to court. But the claim is it's used so often with this child that this child can't receive meaningful educational benefit, and therefore it's a denial of faith. So I'm seeing a bit of an increase in those claims and a decrease in those just personal injury money damages claims for the use of restraint and seclusion. My prediction is that I don't think we're going to see anything out of Congress on this issue. I think that the U.S. DOE will continue to try to support the proposition that states should be left to their own devices, but certainly any policies and procedures you have in place, you need to actively train all school professionals on those procedures and policies and make sure that those who are restraining are adequately trained as well. With that, it is Friday at 2 o'clock, so I'm going to let you go on to your next sessions. And for the 5 of you that joined me this afternoon, thank you very much. I really appreciated being here in Indiana and appreciate everything you do. Thank you very much.